and a number of bills I'm hoping we can get to after the hearing. So let's get rolling. I'll open the hearing on House Bill 2264. And I did not check to make sure Natalie's here, but I hope she is, and she can give us an overview.
Thank you, Mr. Chairman. House Bill 2264 would permit student athletes at post-secondary educational institutions to receive compensation for the use of their name, image, likeness, rights, or athletic reputation. Section 1 provides definitions that are used throughout the Act. Section 2 provides that a post-secondary educational institution shall not create any rule that prevents a student athlete of that institution from earning compensation for use of those, the name, image, likeness, rights, or athletic reputation. The earnings by that student shall not affect scholarship eligibility or renewal unless otherwise required by federal law or some institutional standard governing need-based awards. Section 2 also provides that an athletic association shall not prevent a student from fully participating in intercollegiate athletics and earning compensation, or prevent the post-secondary educational institution from fully participating in intercollegiate athletics as a result of the student athletes earning compensation. A post-secondary educational institution or athletic association shall not provide a prospective student athlete or current student athlete with compensation. An athletics grant in aid or stipend scholarship shall not be considered compensation, and no post-secondary educational institution shall revoke or reduce such aid or scholarship as a result of that student earning compensation unless otherwise, again, required by federal law or some institutional standard governing need-based awards. Section 3 provides that a post-secondary educational institution shall not interfere with a student athlete obtaining professional representation in relation to contracts or legal matters. They may also not prevent a student athlete from fully participating in intercollegiate athletics as a result of seeking that representation. An athletic association shall not prevent a post-secondary educational institution from fully participating in intercollegiate athletics as a result of a student obtaining representation either. And professional representation on behalf of a student shall only be provided by persons that are appropriately licensed. Section 4 provides that a student athlete will be deemed to have granted the student's post-secondary educational institution the right to use that student's name, image, likeness, rights, or athletic reputation for advertising and marketing related to the post-secondary educational institution. And that will have to be royalty-free and without compensation. Any contractual provision between a student and a third party, sponsor, or agent that's in conflict with this provision would be null and void. A student shall not enter into a contract providing compensation if a provision of that contract is in conflict with a provision in a contract entered into by a post-secondary educational institution. A post-secondary educational institution asserting a conflict in those contractual provisions shall disclose to the student the relevant provisions that are alleged to be in conflict. A post-secondary educational institution shall not enter into a contract that prevents a student athlete from receiving compensation when the student is not engaged in official team activities. A student who enters into a contract for compensation shall disclose the contract to an official that's designated by the post-secondary educational institution, and they have to disclose that within 5 business days of the date of signing the contract. This act does not authorize prospective student athletes who may attend a post-secondary educational institution to negotiate or receive compensation prior to the earlier of either the first day of class in a semester in which the student is registered for full-time courses, or the first day of practice or competition in intercollegiate athletics. Section 5 provides that the act shall not apply to a contract executed before the effective date, which is January 1, 2022. It also does not apply to any accredited not-for-profit post-secondary educational institution where physical presence in the state that is exempted from the Kansas Private and Out-of-State Post-Secondary Educational Institution Act if that institution elects to be exempted from the provisions of this act. A legal settlement arising under this act shall not permit non-compliance with the act. And if passed, the provisions of this bill would become effective on January 1 of 2022. And I can take any questions.
Natalie, our first question's from Representative Hoheisel.
Thank you, Mr. Chair. If I may, I do have 3 very quick questions. Natalie, I'm just curious, does this prevent or not prevent, I guess, an athlete from signing with an agent?
Mr. Chairman, Representative Hoheisel, that provision, I alluded to that. Let me find exactly where the section is. But a student athlete would be able to sign a contract with an attorney or an agent, so long as that agent was appropriately licensed in the state of Kansas.
My second question, if I may, Mr. Chair. When we talk about compensation, and I'm just going to use a high-profile story from a number of years ago involving a college athlete who received, I believe, 1 or 2 tattoos and signed some autographs for the tattoo shop, and received some punishment from that. Would this ban that kind of punishment? Would that be allowed under compensation?
Mr. Chairman, Section 1, which provides the definitions for the act, doesn't actually define compensation, but I assume just under like a normal meaning of compensation that would be included, and so that would be allowable.
That's enough for me. Thank you, Mr. Chair.
Representative Samsel.
Thank you, Mr. Chair. I heard the good representative from Wichita singing our alma mater. I'm wondering if, in fairness to the other proponents and others across Kansas, if he should do the Wabash Cannonball for us, but I'm a little bit afraid of that. But my question for Natalie, it seems like this is allowed, and I may be jumping the gun a bit, but does this, I don't see in here, when we say they're allowed to be compensated, we're not getting into the specifics of how much, who, from, all that type of stuff. I'm not missing that anywhere, am I?
Mr. Chairman, no, that this just kind of opens up the gate to allow those contract negotiations to take place. So it doesn't get into the specifics of that.
Thank you. Thank you, Mr. Chair.
If you do need someone to perform the Wabash Cannonball, I'm pretty able and willing to do that for you.
Sounds like worthy of a motion. Thank you.
Oh, Representative Hoheisel again.
Thank you again, Mr. Chair. First off, I just would like to point out that the best basketball team in Kansas, the Wichita State Shockers, play tonight at 6 o'clock on ESPN2 against the number 6 ranked Houston. So I just wanted to FYI for everybody. Natalie, I have one question here. You referenced it as far as what the universities can do with the image and likeness. Would this allow universities, and I guess the NCAA as a whole, to create a video game and use the image and likeness of that student athlete, and that athlete would not be eligible for any royalties or compensation for that?
Mr. Chairman, that's an interesting question. So the provisions of this bill mostly talk about what the student athlete can do, what the post-secondary educational institution can do, and then it puts some parameters on what an athletic association can and cannot do. Mostly it says an athletic association can't prevent participation in intercollegiate athletics, either because the post-secondary institution is allowing this to happen or because the student has entered a contract to get representation. The provision relating to use of the educational institution, it's on page 3, it starts at line 19. It's the first part of section 4. So it says a student athlete shall be deemed to have granted the student's post-secondary educational institution the right, royalty-free, without compensation, to use their name. So it would have to be that the post-secondary educational institution is, trying to enter into a contract for use of a video game. But I think it does say at any time for its advertising and marketing related to the post-secondary educational institution's athletic interests. So I'm not sure that's would really be covered here.
Thank you for that, Natalie. Thank you, Mr. Chairman.
You're welcome. And Representative Hoheisel, just a warning, I do have 7 bills I want to work today, and so you may miss that game. But let's see, Representative Curtis.
Thank you, Mr. Chairman. And Natalie, just to clarify, this bill only pertains to student athletes. It doesn't include any measures dealing with creative content that is perhaps created by student artists or innovators, as far as, facilities being able to use them they're creations for royalty-free use, right? It's just dealing with athletes. It's a little bit of a facetious question. I'm sorry.
Mr. Chairman, and I don't think that really is facetious, because if you look at the definition, it's on page 1 there, starting at line 31. So student athlete or athlete, we have a definition there. So they do have to be participating in varsity intercollegiate athletics, who's part of that institution. So, depending on how that's interpreted. But
Thank you.
Any other questions for Natalie? Representative Jennings.
Thanks, Mr. Chairman, and not to delay the proceedings here, but it seems to match actually with the subject matter of this bill that, K-State KU played last night on ESPN Plus, and of course, Wichita will be playing on a free station. I guess that just goes to prove you do get what you pay for.
Moving on to proponents. Committee, and I've shifted the order on the agenda just a little bit based upon who's here and availability, and President Garrett has found internet connection. Oh, there she was scrolling there for a second. So we're going to start with President Garrett.
Thank you so much, Mr. Chairman. Can you all hear me?
Yes, we can.
Okay, very good. Well, thank you for allowing me to speak today on House Bill 2264 regarding student athletes' ability to seek compensation from third parties for the use of their names, images, and likenesses while they're playing college sports. Just really quickly, and I won't read my testimony to you, but I wanted to mention a little bit about my background that might be somewhat relevant.
President Garrett, not to stop, well, I guess to stop you for a second. Your internet feed has slowed down a little bit. I wonder if you stop your... Yeah, that may help. So how about everybody, if you don't mind hiding your picture until I call on you, and let's see what that does.
Just
We'll give her-
elected. Can you hear me adequately?
We can now. I think it just got caught up there. Try again.
Okay.
There we
Okay.
go.
So in addition to serving as the president of Emporia State, I was just elected to be the president of Division II for the country. I'll serve as the chair of the President's Council, which is the governing body of Division II, starting this summer. And I've been on the NCAA's Board of Governors for some time. And long before I entered higher ed, I did a stint in the corporate world and served as a general counsel for a large company. When I share with you my views today, I want to be clear that I'm not speaking for the NCAA or the MIAA or the Kansas Board of Regents. As a Division II school, we're very much focused on life in the balance and focused on assuring that our students are able to graduate well prepared for life, because quite honestly, even at the Division I level, very few student athletes will go on to play professional sports. One thing that I want to make sure is clear is that this is not pay for play legislation, but it's a pay while playing legislation. In other words, if I am a student athlete, can I seek to engage in some sort of contract with a third party that allows me to be compensated when that third party uses my name, image, and likeness? And the NCAA has allowed this for some time, but it's been a little bit of a cumbersome process. And of course, some states like Florida and California and their legislation have really caused other states to be very interested in moving forward with something like this. One thing that is of tremendous concern to me as a college president, as well as someone who's involved with the NCAA, is to assure that wherever we land, at the end of the day, there's a uniform national approach. And so while I think it's important for Kansas to put its stake in the ground, as other states have done, at the end of the day, I believe Congress will need to act in this area. I also want to mention just a few areas of concern. First, I think it's incredibly important that we maintain that distinction between someone who's an amateur college athlete and a professional athlete. And that may require some nuances in whatever NCAA legislation eventually comes from the state legislation or federal legislation that addresses this topic. We also need to make absolutely sure that college athletes don't become employees of their universities, because that brings with it a host of other challenges in interacting with the college athletic teams. One other thing that I believe will likely come to pass will be that we will see some real distinctions between the pay for play that is available to men and what is available to women. And certainly we're all aware that Title IX has been a great tool for helping to balance opportunities for both men and women. And I hope that this does not somehow create imbalances, though it is likely that the athletes that will get the most attention are those in men's basketball and football. I also believe it's going to be really difficult for the universities to monitor this. It's going to be a complex area, depending on the kind of organization a student athlete might ink a contract with. That contract itself might be extraordinarily complex. And I think we would see huge differences in the level of contract negotiation and even representation that is selected by the student athlete at the D1 level and with athletes at the D2 or D3 level or NAIA athletes. We have to be sure that this model is not somehow used to incentivize recruiting. In other words, the student athlete, as has already been mentioned, can't ink a contract until they are already at the institution. To do otherwise makes it look like it's being used to create an unfair incentive in the recruiting of student athletes. And then the last area of concern that I have is, the college level, there are those couple of larger sports, and then there are many other sports that are played that are important as part of the process to develop athletes to compete in the Olympics. And I think those athletes are unlikely to have the same sorts of lucrative deals that Division I basketball and football players have. And so assuring that we're careful that those other sports are not somehow harmed by this would be really important. I mentioned my hope that Congress will act. Let me just share a little bit with you about what we were poised to do at the NCAA back in January. All three divisions of the NCAA had, through various committees, spent a tremendous amount of time working on what a structure would look like to allow for this area to be clearer and open up opportunities for student athletes to profit from their name, image, or likeness. We were all poised to vote on our legislation at each level last month, but the U.S. Department of Justice Antitrust Division asked that the NCAA not do that. And so the NCAA has not yet acted. And so again, my hope is that Congress will be able to act fairly soon. I just want to note one other thing that I think is really important, and that is that monitoring this is something that could be incredibly complex for universities. As a Division II institution, we have one person who does compliance work, and this really opens up complexity with contracts that, a single individual who does routine compliance work may not be well equipped to perform. So I do think it's important that we be mindful of the additional compliance challenges. One other compliance challenge that may present itself will have to do with team rules. And I mention that just because I think it is appropriate to note that I believe institutions would have concerns about the types of contracts that a student athlete might enter into. And for lack of a better example, I'll just kind of use the phrase vice contracts. So if someone who is a high profile student athlete who's looked up to by young people is suddenly out there pitching alcohol or vaping, I think that's going to be a concern for our institutions, because those would be activities that coaches would prohibit their student athletes from engaging in during the competition season. So those are just a few thoughts that I had with respect to the proposed legislation. And I appreciate so much the opportunity to share those thoughts with you today. I'm open for any questions you may have.
Great. So we've got at least a couple. Representative Samsel?
Thank you, Mr. Chairman. Thank you, Madam President, for being here today. Two quick questions. I hope they're quick, if I may. Can you help me understand a little bit better what the status quo of the law is right now? So meaning if we don't pass anything today, and I realize there's no opponents to this bill, but if we don't pass anything, what does this look like moving forward?
So I think the NCAA will attempt to act, I think, in the next several months. But I know there is activity in Congress right now. Senator Moran has been involved in that activity to try to get Congress to act, because at the end of the day, a patchwork of 50 different states' laws is going to be incredibly complex, almost impossible to assure a level playing field. There are a couple of states that have laws that become effective fairly soon. And I'm speaking from memory here. My recollection is that the Florida law becomes effective this summer. And so, you know, if there's not action by the Kansas legislature, I don't personally feel strongly that there would be any imminent harm to Division II, because we're not competing typically against schools from Florida for talent. But my colleagues from the Division I schools might have a different take on that.
So current law doesn't allow them to be paid right now. Is that accurate?
So it's not law, it's NCAA regulations, but student athletes can apply to the NCAA for an exception, and the NCAA will grant that exception, provided that it's pay for something that's a little bit attenuated from direct competition. And I'll give you a quick example of that. So if you had a student athlete who is a fabulous musician and who is laying down the most exciting football tracks anyone has ever heard, that would be the kind of thing where they would say, you know, making music is something that's not related directly to competition, and that would be okay. I think that they would say that's okay.
Thank you, Mr. Chair. My second question, if I may, is I think our reviser very accurately described this as opening the gates, not to misquote her or mischaracterize her there, but if we do proceed forward with this, and I think I hear everybody, that's why we've got proponents, is saying this isn't perfect, but it's better than the status quo. But if we do open these gates, if you will, not to pick on my good friend and representative from Wichita, but is there anything in here? I mean, do you guys have concerns about, let's say, some of our friends in Shocker Country versus Wildcat versus Jayhawk and Hornet and all of our friends across the state of Kansas, if you will? If compensation really is what we're getting into, what guidepost or, you know, fair play, all that good stuff, anything on that? Is there anything in the bill that addresses that right now, or anything that we should be considering, just so that to make sure we've got, we all love our competitions, but to make sure that those continue to hopefully be fair?
Was that question addressed to me or to the reviser?
President Garrett, if you have any response to it.
Yeah, so I think within Kansas, it can still be fair. And at the end of the day, you know, a high profile student athlete will and higher fees or payment for the use of his or her name, image, and likeness. And that's something that, you know, if you look at other industries, is not surprising. If you look at, you know, Hollywood, you see differences in compensation among men and women. But if you look at modeling, you see differences where the women are more highly compensated. And there are a few who end up being the standouts and, you know, to whom a lot of the deals are directed. And so it will be, I think, very interesting. Our student athletes, the challenge for them will be seeking representation, because they're going to be, I think, a little bit at sea. You know, many of them are 18, 19 years old and do not have experience with complicated contractual matters. And for the most high profile of the student athletes, and here in Kansas, I would think it would be the D1 student athletes in those couple of sports I've mentioned, those contracts could be extraordinarily complex.
Well, and actually, President Garrett, my very narrow concern is if school A here in Kansas, and let's just say it's a D1 school, can offer student A, you know, a $50,000 compensation package, if you will, for lack of a better way to say it. But our counterpart, school B, same D1, can only offer theirs maybe $5,000 or $10,000. I mean, is there any caps or I guess guideposts to make sure that we're not using money to give one school in Kansas an advantage over another school?
Well, so it's not the schools who are compensating the athletes. And I believe that the bill attempts to address that by noting that the student athlete is prohibited from entering into negotiations or deal prior to enrolling at the school. And so what could become problematic is, how do you know that there weren't discussions before the student athlete enrolls at a particular school? And so high school coaches will have to be knowledgeable and able to coach their star athletes to not even talk to a third party before they have signed with a college.
Thank you, President Garrett. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you. President Garrett, you're obviously very knowledgeable about these matters, and I appreciate you sharing that knowledge with us. Several areas I have of concern, but let's turn first to Representative Hoheisel's question. If Emporia State University wants to develop the Mighty Hornet app and sell advertising on the Mighty Hornet app, under this statute, they can use the pictures, the images, the likenesses, etc. of the student athletes without any compensation whatsoever, the student athlete, but the athletic association can bring down the big bucks, I think. Would that be possible?
So it is accurate to say that all of the schools would be able to continue to use for their own purposes that student athlete's name, image, and likeness. My understanding is that continues to be the case in the bills that have been passed in the other states and in what the NCAA was prepared to move forward with. So it's always been the case that, you know, if you're doing a poster with your football team season and all the games listed on it, you know, you might have the whole team on it, but you might have one or two star players on it, and you have a right to do that. And because you are typically scholarshiping the athlete to play for you, you don't have an obligation as an institution to pay additionally. If you did, then I think you start to run into those real concerns about, our student athletes really employees? And that would bring with it a host of significant concerns.
Like maybe unionization?
Could be.
Yeah, but the real thrust of the question I was asking actually goes beyond that. We know the institution can probably do that now. But under this legislation, the commercial gamblers who want to bring pari-mutuel wagering into Kansas, with all of the concerns that we have about how that might influence the outcome of games and so on, it sounds like they would be able to literally retain student athletes to endorse their gambling platform over somebody else's. Or more importantly, what's actually going on, at least right now, is licensing of NCAA logos and the like. Student athletes would be able to contract with gamblers under this provision, wouldn't they?
Well, that's why I raised the concern that I think it's important that the institutions do have the ability to exercise just a modest amount of control so that you don't have student athletes advertising things that they wouldn't be allowed to participate in during the season. And I think sports wagering is another great example. And I know sports wagering is also in front of a number of different states. You haven't asked about this, but I'll share that, you know, I'd certainly prefer if Kansas were to move ahead with sports wagering, that it not include collegiate level sports wagering. And I think there are all sorts of concerns with how that would work, particularly the intra game. Is he going to make this free throw or is he not? And so I do have concerns about exactly what kinds of third parties student athletes could move forward with. Let me mention one other thing, because this was maybe a little bit related to your question. It is my understanding that because our institutions all own their intellectual property, meaning their team logos and that sort of thing, that they could say that even though, you know, star athlete A can ink this great deal with the car dealership, that star athlete can't be wearing his or her jersey while doing that promotion for the car dealership. I think we have the right to do that because the logos are the university intellectual property.
President Garrett, I don't disagree with a word that you said, and I really appreciate you giving us this perspective. I want to reserve some time for questions from your more wealthy colleagues from Big 12 or whatever they are this week institutions, because that's where we can talk about the car dealers' involvement. Thank you very much.
You are most welcome.
Representative O'Hobbison.
Thank you very much. Can you hear me?
Yes.
I can.
Okay. Thank you very much, President Garrett, for joining us today. My question kind of falls in line to what my good friend, Representative Samsel, asked as to are there any caps going to be placed on, you know, incentives per se for some of these players? Because if we're talking about, you know, star players, are incentives going to be, are there any caps per se, say for instance, on a particular program, whether it's basketball or soccer, for both men and women? Or is it up to the school to decide what the caps are, or is this going to be like a free fall as to, whatever amount that we can afford? I mean, what's pretty much your take on this? That's what I'm trying to understand.
So as I look at this draft legislation, and I have a little bit of familiarity with some of the legislation from the other states, my understanding is that none of the states are putting caps on what those third parties could pay to student athletes. So you could have a student athlete who's at Emporia State and maybe on a full ride basketball scholarship, but who's making $100,000 on the side from a third party for the use of his or her name, image, and likeness. And so if the bill doesn't contain caps, then there won't be I don't think, the ability of universities to put a monetary cap on a particular student athlete.
So my question will be, if, a university is spending X amount on male players, but are not spending it on female players, or vice versa, will that actually open up lawsuits within the university by athletes as to not unfair advantage to either side, either sport down the road?
Well, we are all obligated under Title IX to assure that there are equitable opportunities for female athletes. And that what really was the genesis of Title IX, because particularly when you think about how huge a football team is, you need several women's sports to be
Right.
able to provide an equitable number of opportunities. This takes that equity calculation, if you will, out of the university entirely. This is what a third party is doing with an athlete. It has nothing to do with what the university is doing with the athlete. But I am concerned about there being continued perception that there is inequity among men's and women's sports, and
Right.
concerned about the impact potentially on Olympic sports. If you see all of the money going to athletes in just a couple of sports, then I think there's the possibility that our Olympic training programs could potentially be hurt. I know I've seen some indication from people who are far more expert than I that there's a little bit of a concern about that.
So in other words, I'm thinking of like unfair advantage within a particular sport, like within a university, with respect to, say, for instance, basketball. And not to pick on anybody. I see my good friend from Wichita, who's a Jayhawk fan. Say, for instance, a men's basketball, women's basketball, any particular any sport. Say, for instance, the men's are spending X amount on trying to recruit players, but they're not spending the same amount trying to recruit on the female side. I'm just trying to understand whether or not this will lead to some kind of problems down the road, some kind of lawsuit down the road for any of the universities. I mean, that's what I'm trying to get at.
I think this is more of a perception issue, because we all are governed by Title IX, and also governed by the number of equivalencies that are allowed per sport for each of our divisions. And so for Division II basketball, we've got 11 equivalencies, and we can give those out to men and we can give those out to women. And every university has to really pay attention to whether they are in fact being equitable as far as the ways that they're supporting opportunities for men and women. Where this becomes challenging is that this is something that is outside of the universities, because this is something that an athlete outside of the university is negotiating with a third party. And the university has no control over that third party.
Okay. Thank you, Mr. Chairman. Thank you very much, President Garrett, as well. Thank you, Mr. Chairman.
Certainly.
This is going to be the last question for President Garrett. Representative Hoheisel.
Thank you, Mr. Chair, and thank you, President Garrett, for being here today. And my question is rather quick. Is it your understanding of this legislation, it would allow an athlete to negotiate with a third-party video game maker, say EA Sports, and they would be allowed to use their name, image, and likeness in that video game? Is that your understanding of this legislation?
Absolutely. But as I mentioned earlier, whether they would be allowed to, in the video game, have their image shown using their school's jersey would become kind of complicated. It might be that a particular school would say, that's great. We think it's great advertising for the school, and we give you permission to, authorize your name, image, and likeness to be used in the video game while you're wearing our jersey. But in other instances, the school might say, no, we're not comfortable with that.
In those instances, I know something EA Sports is doing with their new football game that they have coming out, I believe in 2024 or 2023, is they're also working with the collegiate licensing company to be able to use those, logos, uniforms, and all that. So, okay, that kind of answered my question. Thank you, Mr. Chair, and thank you, President Garrett.
You're welcome.
Okay, thank you, President Garrett. Now that she's leaving, I think, as long as you have ESPN Plus, I'm going to allow you to start your video. Is that not funny? I don't have ESPN Plus, so I can't watch my video. So go ahead and start the video so we can see each other. And then I'm going to allow both athletic directors to speak, and then we'll do questions at the end of both of them. And that way, if one doesn't cover it, then you can ask the question. So next one up is Jeff Long.
I was hoping that you'd have Gina and I speak at the same time, because that would probably make more sense out of what we're trying to explain to you today. But that was an attempt at a joke. But good afternoon, Chairman Patton and distinguished members of the committee. As you know, I'm Jeff Long, Athletic Director at the University of Kansas, and very proud to be so since August of 2018. Wanted to speak today, as you know, in support of House Bill 2264. College athletics continues to navigate uncharted waters, and the future of competitiveness of university intercollegiate athletic programs in the state of Kansas could be at risk if we do not enact this bill. The Fair Pay to Play Act, passed in California last year, has accelerated the push to change NCAA rules that would provide student athletes the opportunity to profit from their name, image, and likeness, also known as NIL. After California Act was signed into law, a number of other states began crafting legislation to permit student athletes to monetize their name, image, and likeness, including Florida, whose similar bill is set to go into effect of July 1, 2021 of this year. In an effort to avoid being at a competitive disadvantage when recruiting against universities located in states that will permit their student athletes to monetize their name, image, and likeness, our great state of Kansas must be ready with HB 2264 or risk the future of our historically successful athletic programs being at a disadvantage. Currently, at least 35 states have introduced or passed bills or have bills pending on this matter. So without a state law in Kansas that permits student athletes to monetize their name, image, and likeness, the University of Kansas and our fellow state universities will be placed at a disadvantage. First, state laws on NLI will supersede the NCAA rules, which create inconsistencies in the recruitment of student athletes from state to state. Secondly, without a Kansas law on NLI, institutions in Kansas will be left to follow what I believe are outdated current NCAA rules, which will result in a significant disadvantage to us. Kansas must be prepared to enact this bill to address the complex matter and allow our universities to remain competitive in every sport each institution offers. You know, the definition of amateurism is in the process of changing in our country, and we believe that when the process is complete, college sports will be forever changed. While we do believe the NLI monetization will eventually be regulated at the federal level, until that's formalized, we must have the ability for our student athletes in the state of Kansas to follow the state rules that would allow for the monetization of the name, image, and likeness. While we expected the NCAA last month to move on these rules, now the process likely will not be complete before many of the state bills go into effect. And if Congress fails to preempt these individual state laws, as stated before, Kansas universities will be left to follow the NCAA rules, which will put us at a significant disadvantage. Each state bordering Kansas already has similar NIL bills pending. So with this urgency, we respectfully ask for passage of HB 2264. This bill will permit each Kansas college or university competing across all three levels of the NCAA to have the opportunity to remain competitive in recruiting and in competition. In addition to providing student athletes the opportunity to monetize their name, image, and likeness, we believe HB 2264 will help prevent the movement for student athletes to become employees of an institution, which we believe would likely eliminate opportunities for men and women who compete in collegiate athletics. If student athletes become employees, many believe this would quickly lead to a dramatic reduction of the number of sports sponsored by an institution, with a particular impact on our non-revenue and Olympic sports. Not only would college athletics become unrecognizable, it would have a disastrous impact on our U.S. Olympic model, because 80% of Olympic athletes matriculate through the college system. If the NCAA cannot garner enough support for national legislation, or if the U.S. Congress elects not to act or is unable to do so in a timely manner to preclude individual state bills from going into effect, the state of Kansas must be prepared with this bill. The new administration in Washington, D.C., it remains unclear how Congress will respond. Therefore, we anticipate a lapse in time between the effective dates of the NCAA's request of federal legislation and when state laws go into effect this summer. HB 2264 will ensure colleges and universities within our state are not placed at a disadvantage in this interim time period. I thank you for this opportunity today, and I will be happy to take questions at the appropriate time.
Thank you. Next, we have Gene Taylor.
Thank you very much, Chairman Patton and members of the House Committee. Appreciate the opportunity to visit with you today. As you all know, my name is Gene Taylor. I'm the Director of Athletics at Kansas State University, and I've been here just over 3 years. I also appreciate the competitiveness of the committee, talking about their institutions and supporting them, so that's always good to hear. You guys made a great move by starting with President Garrett and Jeff, because I'm not going to add a lot out of my testimony, because they've covered pretty much everything that I wanted to touch on, in particular in support of House Bill 2264. I do want to just touch on a couple of things. Obviously, I've been in this business a long time, and I've seen this change a great deal in the NCAA. I've been at every level. I've been at Division II. I've been at the FCS football level. I've been, and now, as we call it, the Autonomy 5 level. And we have made great strides in taking care of our student athletes. And I think one thing I want to stress is I don't want to lose sight of the fact that a full scholarship student athlete is well taken care of on all of our institutions. We've done things that people talk that really aren't clear on. We do have medical care beyond their graduation, that if they still have injuries or they're dealing with injuries post-graduation, we have the ability to take care of them. We honor every student athlete that wants to come back and get their degree an opportunity to do so. A full scholarship student athlete with tuition fees, room, board, and books at Kansas State University, when you add in the cost of education, which we started a few years ago, a student athlete could be compensated between $3,000 and $6,000 a year per student at various institutions. For here at K-State, an in-state student athlete with all the things they get, tuition fees, room, board, books, cost of education, when you add in support like strength and conditioning, athletic training, medical care, travel, equipment, the value of that scholarship in-state is about $75,000 a year. And for an out-of-state student athlete, it's about $91,000 per year. And so it's not like they're not getting taken care of, but this just gives those student athletes an opportunity to take advantage of not only their name, image, and likeness, but their talents. And President Garrett talked about that. If you have a talented athlete that's a musician or an artist, they should be able to benefit from that. If you have a student athlete that's very good at the social media world, they should be able to benefit from that. And that's what this bill is going to allow us to do. As President Garrett and Jeff talked about, there are concerns. We can't be late to the table because it would become a recruiting disadvantage. But at the same time, within recruiting, we do have to recruit our student athletes. They choose to come to our institutions. Now, they're not drafted. And so within that, we want to make sure we have guardrails in here so it doesn't cloud the recruiting process, as was mentioned earlier. So we have to protect and make sure the recruitment is still fair and equitable, not only in the state that we live in, but across the country, as Jeff talked about, because we do recruit against other states and other institutions across the country. The Title IX that was mentioned, absolutely incredibly important that we protect Title IX and are fair to our women athletes in particular. We need to make sure we continue that and protect that as best we can. So those were the things that I really wanted to touch on. They're all very important. The House bill needs to pass because there are legislation across the states, as we mentioned, Florida starting in July of this year, as is Iowa, I think, just passed one. So we need to make sure we move, but we need to make sure this is protective of the institutions, but gives the student athletes the necessary opportunities to earn additional compensation or additional money from their name, image, and likeness. And with that, I'll wait to hear from questions from anybody that has them for Jeff or myself.
The first one I have is Representative Samsel.
Thank you, Mr. Chair. Mr. Long, very briefly, thank you for being here today. I just want to make sure when I go home and explain this to my constituents later, right now, I understand that it's the NCAA that has rules and regulations that currently prohibit student athletes from receiving compensation. Is that correct?
That is correct, but we're facing antitrust lawsuits for that prevention of student athletes to engage in monetizing their name, image, and likeness.
And I think I understood that if the Kansas legislature passes this law, that would essentially trump, or at least arguably trump, the NCAA rules and regulations.
Yes, that's my understanding, that would take precedent, just like Florida and the other states. But please keep in mind that the NCAA has asked very openly for federal intervention here and asked for laws that would bring all 50 states under the same guidelines for name, image, and likeness. And what HB 2264 does for us, we anticipate there may be a gap between the NCAA, the new Congress, and the new president being able to get to this issue before the state laws go in effect. So in many ways, what we're asking for here in Kansas is this bill to pass, get us through this period that we anticipate where it's going to be, quote unquote, wild, wild west. Every state's rules will be in effect in their state until the federal government gets to preempt these state laws and then puts in a federal across all 50 states legislation.
My last question, very briefly, if I may, Mr. Chair. I understand we need to act with all urgency, but is there any particular hard deadline or something where this needs to get passed through both houses and signed by the governor?
Sorry, who was that question for? I'm sorry.
If either, well, and not to put anybody on the spot, but I'm just curious, is there, I mean, we're going to act with urgency, but is there a hard deadline or something that we need to be aware of to make sure we get this passed by both houses and signed by the governor? And if anybody knows, and if nobody knows, that's fine too.
No, I'm sorry. I'll answer it by saying this, and Gene may have a different perspective, but I think that July 1 is when Florida goes into effect, but we're not as current about that. As you see, the start date of this bill is January 1, 2022. We believe that we're hopeful that there will be federal national legislation in between July 1 and January 1 that would take place. But there is no guarantee that that will take place. So if it hasn't happened by January 1, 2022, we feel like then we need to have the ability in the state to recruit and be competitive against everyone else who has enacted these laws in their individual states.
Thank you, Mr. Long. Thank you, Mr. Taylor. Thank you, Mr. Chair.
Thank you.
Carmichael.
Thank you, Mr. Chair. I'm critically aware that the hour is comparatively late and we have a heavy docket of bills to work yet today. But I certainly hope people understand that I don't share Representative Samsel's belief that we have to pass this right away. That being said, could either of our athletic directors explain to me why it is they believe that passing a law like this in Kansas would prevent the NCAA from declaring players ineligible because they are in violation of NCAA rules? Why do you think the state of Kansas can tell the NCAA, other than the fact that they're in Overland Park, but why do you think that we can tell the NCAA what their eligibility rules should be?
You want that, Gene?
Yeah, I'll touch on that. And what I'm in kind of what Jeff is talking about from the federal perspective, we also feel that the NCAA already has a lot of language that are very similar to what's in this bill that they're prepared to vote on and pass sometime this summer. The only reason I think President Garrett touched on it is it got stopped because of the Supreme Court's willingness to hear a case against the NCAA. And that we anticipate to have an answer to that sometime this summer, maybe as early as June. They're going to hear the case this March and then present their findings in June. Once we get that, that's going to hopefully give us a direction. And I think the NCAA is prepared to come out with legislation soon after that. That's going to be probably very similar to a lot of the state bills. There may be some that will be a little different, but I think you're going to see a lot of the language that is in this bill that the NCAA has talked about, giving the athletes the rights to many of the same things that this bill. So it wouldn't necessarily be in conflict. There are some pieces that might be that we'd have to work through. And that's where we'd hope that the federal legislation would come in before maybe even August of this year. So it's gonna, a lot of worlds are going to collide here over the next several months. It could make this very interesting for sure. And I know, for instance, the NCAA has talked about an injunction in Florida with their bill because it does take effect in July. How successful they'll be, I don't know. But it's going to be very interesting over the next several months.
Well, Mr. Taylor, one thing we certainly agree upon, this cries out for action by the United States Congress for uniformity of law and a way to make sure we're not in violation of antitrust. And there's just a whole host of things that say this appeal ought to be made to our senators and congressmen. But let me ask you, if I could, a different question. My father taught me that it was absolute gospel that players at the Spitzer Rod and Gun Club located in Oklahoma at Norman, I think it was, they said, that they were all on the take from the car dealers. Now, I don't know if that's true or not, but that's what my dad, who was an A&M Aggie from Stillwater, always taught me, and I took it as gospel. But as I understand it, under this legislation, if I were a wealthy car dealer in Manhattan, I could make it known to the world that I hire every starting football player at $100,000 a year to come into my place of business and sign a poster saying I endorse John Carmichael Motors. And that's, the university couldn't stop it. The law wouldn't stop it. But it puts out a big sign that if you're good enough to be a starter at K-State, you're going to get $100,000 from Carmichael Motors starting your first year on the field. Is that a really good idea for student athletics to have that kind of a situation?
I'll answer that by saying no, it's not. We hope in the federal legislation there will be protections in there that will require whatever student athletes learn for that promotion of your automobile dealership be what it market driven. Now, we still have to understand what market is, but we understand that one of the things being considered at the federal level is a third-party group that would assess the value of that student athlete signing a poster promoting your car dealership, and that would have to fall into a market range for that kind of promotion. Just as doing a television commercial, just as supporting your business on social media, these would all be market-driven forces, and that's the way we would avoid these antitrust lawsuits that just are lined up against the NCAA and individual institutions as well.
But Mr. Long, none of those protections are in this bill. You're relying on the Congress to act, and if the Congress acts, then I don't think we need this bill at all, and that's honestly what I prefer to see happen. Can you help me understand why you'd want to create that situation in Kansas in the interim?
Yes, sir. Because there'd be 35 or more states that would have something similar to that wild, wild west. And if we are bound by not being able to offer student athletes the opportunity, it's their opportunity to earn it. We don't provide it for them. We don't set it up for them. We educate them. we'll be responsible for monitoring, we'll be responsible for NCAA compliance. But if we don't have it, we won't get recruits for that interim period. And again, we hope there isn't an interim period. We hope that Congress will enact a bill that covers all 50 states. That's what we want. Unfortunately, we've not seen the NCAA be able to move that process, or with the change in leadership in our government now, how quickly they're going to get to this issue. So this bill is solely to help us through an interim period if it occurs before federal legislation comes into effect.
Mr. Chairman, I could continue for the rest of the afternoon on this with a whole bunch of important issues, but I understand time is short, and that's one of the reasons I hope actually we don't work the bill. Thank you, Mr. Chairman.
Questions, committee? I do not see any. We have one additional written proponent testimony from the Kansas Independent College Association. You should all have that emailed to you. Is there anyone else in person or online as a proponent? Don't see anyone as a neutral conferee. Seeing that either. Are there any opponents? Not seeing any. We will close this hearing on House Bill 2264. Thank you all for joining us today.
Thank you.
Go Jayhawks and Wildcats when they're not playing the Jayhawks.
Thank you.
Have a good evening. And the Hornets. And the Shockers. Yeah, everybody, go all Kansas schools. There we go. Okay, committee. I'm going to maybe move these around a little bit, Natalie, just to hit those that we either have people here or stuff we've already talked about a little bit. But let's pick back up with 2093. And Natalie, if you just want to do the briefest of reminding us what this is, or you can read the whole thing. Some people probably didn't catch it the first 4 or 5 times.
Mr. Chairman, House Bill 2093 makes changes to the criminal penalties for flee and elude. It also makes fleeing and eluding prima facie evidence of theft in a prosecution for stealing a motor vehicle. And I can take any questions.
Not seeing any questions for Natalie. Are there amendments? Representative Owens.
Thank you, Mr. Chairman. Take 3, except for we're going to start with one of the other amendments first and see if we can't move this along a little faster. Does everybody have the amendments at this point?
I'm not sure everybody has the amendment, your new amendment.
Okay.
So
we can work on sending that one out, but everybody should have the other 2 amendments. And I'm specifically looking at the amendment that deals with prior convictions, is what it's titled. 2093, the document's 2093-prior conviction.
So this
would have probably came 2 or 3 days ago.
Mr. Chairman, this one was distributed the first time, but if you do want me to send all 3 of them to Kathy again, I can.
Let's do that. Let's send all 3 because I know everybody doesn't necessarily have all their documents with them.
And Representative Owens, I will share the prior convictions one here for you.
So while
while she's sharing that, I will just briefly explain. All we did here is we clarified the prior conviction portion of this on page 2. You can see where we struck out first conviction is and replaced it that when a person is being sentenced and has no prior conviction. So it's more of a clarification to make sure that we're getting the right people based on their prior convictions. And again, these amendments came as a result of prior conversation and working with the bill author and making sure that hopefully by the time we're done, we have made the necessary changes. So with that in mind, I don't know if you're ready for a motion. Okay. Then I move my amendment, Mr. Chairman.
Thank you. With a second by Representative Hoheisel. Discussion on this amendment? Not seeing any, you can close.
I close.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. Back to Representative Owens. In committee, I do believe that the amendments have been emailed out.
All right, so we're going to move to one that is titled 2093 Driving Wrong Direction.
Did you all hear that? So it's amendment to 2093, and the title is Driving Wrong. Did you say direction?
Yes.
Okay. Way. Driving wrong way.
Wrong way.
Okay, if you'd like to explain it.
Okay, so this was clarifying, let's see, when the motor vehicle willfully fails and then goes on to commit additional crimes when they fail to stop when they're supposed to. So this adds number 3 that says when they willfully drive the wrong way into an opposing lane of travel on a divided highway as defined by KSA 8-1414, amendments thereto, willfully departs the appropriate lane of travel into an opposing lane of travel on any roadway, causing an evasive maneuver by another driver, willfully drives through an intersection, causing an evasive maneuver by another driver, or causes a collision involving another motorist. And with that, I will move my amendment.
Got a motion, second by Hoheisel. Is this the amendment that the Highway Patrol requested?
I believe so, yes.
Representative Carmichael with a question or discussion?
Yes, I do have a question for the carrier of the bill, and I'm not sure this was actually from the Highway Patrol. We did have a Highway Patrol trooper whose father used to work as one of our guards. I can't remember his name. He said this was an anecdotal report that he had received from another trooper from Colorado. I think it was more the 3 law enforcement organizations and Mr. Mr. Klump, who requested this, but be that as it may, my question for the carrier of this amendment is, and I understand quite a bit of this, but willfully drives through any intersection causing an evasive maneuver by another. Would that include driving through a green light or an open intersection? In other words, just because somebody makes an evasive maneuver doesn't mean that act was a separate violation. I'm just trying to find out, even when the fleeing driver is in compliance with the law, crosses through the intersection in a lawful manner, even though there's a red light going behind him, are we going to turn this into a level 7 person felony? Is that what this seeks to do?
No, because they weren't, in that situation, they are not, and Natalie, please clarify the way that we have this worded, because at that point, they're following the law for that specific piece, because they're going through a green light, even though they are eluding police and, could be in a stolen vehicle. But for that specific action, they're not breaking the law. Natalie, would you care to clarify?
Yeah, and let me also chime in here. There's also the requirement that there not only be going through an intersection lawfully or otherwise, but secondarily evasive action by another driver. But yeah, I don't think that this actually accomplishes the intent that I hear from the proponent. I think it's broader than what the proponent intends, but perhaps the reviser can help define that for us.
Hopefully so. Could we also clarify what if they were driving golf carts?
I do intend to get to that at some point, yes.
Excellent.
Mr. Chairman, I'm not sure I can provide too much more insight than what the words are here. You know, it would just be up to a court to interpret those. You know, whether willfully driving through an intersection, if it causes an evasive maneuver or causes a collision. You know, I'm not sure how a court would interpret that.
Well, Mr. Chairman, part of the reason that I ask is the law already provides that 5 or more traffic violations during the course of a chase constitutes, I believe, a level 9 felony. I may be wrong on that. And if we want to enhance penalties for going through an intersection, then I think we ought to make an additional provision, which we can't, but we ought to be able to say entering or crossing through an intersection in violation of other applicable traffic laws resulting in an evasive maneuver. Then I think we're really closer to what we want, because I think this would permit sentence enhancement for people who are lawfully crossing through the intersection. Somebody may have had to do some evasive maneuver for some reason, maybe because they just saw red lights coming. But I don't think this is really what the proponents are asking, so I'm not going to be able to support it. Thank you.
I have worked with the proponents, so I'm rather confident this is what they are providing. So
I am not confident in their drafting skills or abilities, particularly based upon the response you gave to my initial question. Thank you, Mr. Chair.
Further discussion on the amendment? Not seeing any. Representative Owens?
I close.
Close. Heard the motion. All in favor say aye.
Aye.
All opposed say no.
No.
Ayes appear to have it.
Division,
Ayes.
please.
Division's been called. All in favor, raise your hand. 9. Hold on, I can't see online. 10. Okay, all opposed, raise your hand. 1, 2, 3, 4. How many people we have in this committee? Well, it clearly fails. There were 10-ish, 9 or 10 in favor and 4 or 5 against.
So it passes.
It clearly
Passes,
passes.
sorry. Yeah, it passes.
Hey, after the last few days, I'm sure anything could happen.
I know. Okay, Representative Owens, I think you have one more.
Okay, back to the amendment that hopefully you guys all have now as it relates to working through the value of the vehicle and what constitutes theft of a motor vehicle. Again, the whole point in this is trying to take into consideration that even if your vehicle is not worth $1,500, but it's still your primary mode of transportation, it is still incredibly important getting you to and from work and various other things, that should still result in a felony charge. So the amendment that was provided, let's see, changed it to the valuation is between $500 and $1,500. So a value at least $500, but less than $1,500. Again, taking into consideration that the vehicle parked out behind the shed that's going to go to the scrap yard is not worth $500, because at the scrap yard you're going to get $100 or $200 tops. So we're talking about moving and functioning motor vehicles. And with that, Mr. Chairman, I make my motion.
There's a second, Representative Hoheisel, discussion. Representative Jennings.
Thanks, Mr. Chairman. I would inquire of the representative making the motion of what in particular is the desired outcome as a result of making this special classification of felony crime outside of what we have under statute now. What do you think really happens here?
I think in my opinion, it takes into consideration the fact that somebody's primary mode of transportation, the way that they provide for themselves and their family, and pay their bills, rises to a higher standard, and shouldn't be disqualified just because the NADA value shows that it's only $1,000 vehicle.
May I inquire further? So, as I understand your amendment, this amendment would say that if I steal a car that has a value of $500 or more, and I flee from cops, there's a presumption, prima facie case, I'm stealing it with the intent to permanently deprive, and in this occasion, this auto theft would become a felony. So we have a new felony, fleeing and eluding, already, because the fleeing and eluding is going to be a felony because you're fleeing and eluding having stolen a car. And my understanding is that would be a severity level 9 felony, the fleeing and eluding, I believe. Maybe Natalie could tell me. I think that's right.
Natalie, do you want to help with this one?
Yes, sorry, I was having trouble unmuting there. Yes, the current penalty and law there for fleeing and eluding is a severity level 9.
Okay, thank you for that. And then this new felony, theft of a motor vehicle, would be a severity level 10. Is that correct? On the amendment?
Yes, if this
Okay.
were.
And Natalie, maybe you're the best one to ask this. The actual effect of being convicted of a second felony that is a lesser felony than the greater felony of fleeing and eluding is absolutely zero when it comes to sentencing. Would that be a fair statement?
I'm sorry, can you?
Yes,
Yeah.
so for instance, in this case, and let's think about the sentencing grid. The sentencing grid for a severity level 10 felony is as little as 5 months in jail if you have no prior offenses whatsoever, but not more than 13 months in jail if you have 3 person felony convictions prior. That would be the maximum, 13 months in jail. A Class A misdemeanor theft has a maximum sentence of 12 months in jail for the first offense. So I guess the question I would ask the person who's bringing the amendment is, if you want to hold people to account at a higher level, while felony sometimes sounds great, in truth, in this instance, for everyone except a person who has 3 prior person felonies, the misdemeanor threat of punishment's greater than the felony threat. Would that be fair to say?
Well, it seems like a pretty darn valid argument, Mr. Chairman.
And the other argument I would make is that when it comes to criminal history calculation, it is the most serious crime that is committed in the event of committing the offenses that is graded. So this felony wouldn't even be graded on a criminal history if you had a fleeing and eluding conviction with it as well. Is that fair to say?
I'm going to take your word on it, Mr. Chairman.
I believe that's correct. Listen, for a whole lot of reasons, I'm going to oppose this motion to amend, but here's the real reason. It is the history of the state of Kansas for a good long time that we determine value of loss as being the determining factor of whether or not it is a felony crime or not, with some very limited special circumstances, and one of those being don't steal guns, because we know guns are used by criminals in ways that are dangerous to the public. And we want to make sure that that's an enhanced penalty if you go to stealing people's guns, because there's a great public threat here. Loss of a car is a huge inconvenience to people. I don't discount that for a second. But if you take a plumber's tools and you steal the right tools, you put him out of business for 2 or 3 days, he's lost tools, and maybe they're not $1,500 worth of tools. And that's pretty inconvenient to the plumbers. I don't get the logic here. It makes it no more serious of a crime. It sounds like it's more serious. It means nothing in sentencing. And it's flying in the face of a standardization process we've had a long time on the value of loss, determining whether it's a felony And this is not a special circumstance in my mind that warrants that. So I'm going to oppose and vote against the amendment.
I think that your arguments are valid. I wish we'd had this conversation, I don't know, 3 days ago. Because the way that you explain it actually makes really good sense to me. And I don't know that anybody would disagree with that at this point. So with that in mind, I'm going to withdraw my motion, Mr. Chairman.
Representative Hoheisel withdraws his second. We are back on the bill. Are there any further amendments? If not, what's the pleasure of the committee? We've finally gotten to this point. Representative Hoheisel.
Thank you, Mr. Chair. I couldn't stay mad at you forever. I move that the committee pass out HB 2093 favorably as amended.
Is there a second? Second by Representative Owens. You've heard the motion. All in favor say aye.
Aye.
All opposed say no. Those wanting their affirmative votes recorded, Representative Owens, Hoheisel, Neely, Jennings, Heiberger, Carmichael, O'Hobbison. And Kathy, thanks for keeping your mute button on. Now we'll go to 2229. So my list of 7, guys, I think I'm going to try to do, well, we'll see how long this one takes. I'd like to get through a couple more at least. So 2229, Natalie.
Thank you, Mr. Chairman. House Bill 2229 would increase the criminal penalties for multiple thefts of mail.
Thank you. Questions for Natalie? Are there amendments? Representative Jennings.
Well, thank you, Mr. Chairman. I'm so happy to be here and not driving home like I was last Thursday. This is a wonderful experience. Natalie, I think we have an amendment on this, do we not? It's pretty straightforward and simple to explain if it's distributed to everyone.
You do, Representative Jennings. I will distribute that.
I can begin explaining. It's really pretty simple.
Go for it.
I guess I would say if those committee members who serve on corrections and juvenile justice this year or any of the last 3 or 4 years would know that on numerous occasions there's been legislation brought forward to align the felony loss thresholds for certain property crimes with those of the crime of theft. And this particular bill specifically is going yet again to a special circumstance of theft where there are multiple occasions occurring within a short period of time, and it does go to value. So I certainly think subject matter wise it fits. We don't have a 2 subject matter problem. But my amendment in essence is to insert the contents of House Bill 2028, which will align the loss threshold to $1,500 for a list of crimes for which the loss threshold is not $1,500, it is $1,000. The differentiation in this would be things like bad checks. You write a bad check for $1,000, it's a felony. But if you steal my $1,500 cash or $1,499 in cash, it is a Class A misdemeanor. And as I said earlier, we have tended as a state historically to align the determination of whether or not a crime is a misdemeanor or a felony according to the value of the loss, not what we think is inconvenient or less or more important. And this bill came out of corrections and juvenile justice this year, is sitting below the line. And I just think for the economy of the body, rather than having to run the risk of running 2 separate bills, since they are the same subject matter, we run one and it goes along with this one, and it just makes it a bit easier for everybody concerned. So that would be my motion.
Is there a second? Representative Hoheisel. Discussion? Representative Carmichael, then Humphreys.
Thank you, Mr. Chairman. A question for the carrier of the amendment. First, I obviously think that this is a good idea for all the reasons that we learned in corrections. However, this particular legislation at page 2, line 8, is the sequential theft of mail of a value of less than $1,500, even if it's literally a piece of bubble gum on 3 porches becomes a felony. And it seems contradictory to me that we're going to raise the threshold for virtually all property crimes to $1,500, yet when it's porch piracy that Amazon is so very much opposed to, we're going to make the theft of 1 piece of bubble gum off of 3 porches within a period of 72 hours by some kids an absolute felony that will ride with them at least throughout their juvenile, as we say, their juvenile delinquency. But could you help me with that, Chairman Jennings? Why would we want to leave the sequential felony rule in view of your amendment?
Sure. Well, using your example of kids, which is a great example, because I expect, at least in some cases, that may well be the case of who's committing these offenses. If they have no criminal history, they would go through an intake and assessment process and would be afforded an immediate diversion agreement from prosecution, which means that it would really, they would comply with whatever terms and conditions were imposed upon that immediate intervention program. Even if they were convicted of this same kind of offense on numerous occasions, they would never be incarcerated in a juvenile correctional facility. Efforts would be made to reform the behavior. And these things don't haunt kids for life, under our laws, the juvenile adjudication. But let's talk about the adults, because I think your argument certainly has some merit, whether it's a kid or an adult. This goes to, I guess, kind of crime du jour. This is a relatively new phenomena that we're experiencing as a result of a tremendous increase in the number of internet shopping and home deliveries at times when people aren't home. And there is always this deterrent effect of establishing crimes and punishments. It's not likely anyone's going to prison anytime soon if they have otherwise a clean record on these. But it would certainly potentially act as a greater deterrent. Similarly, we do this with firearms, I think, under that same section, as I recall. I don't have it in front of me, but there is a special rule on firearms because of the unique character of a firearm. I think the unique character of this particular offense, maybe at this time it's justified, but the amendment really goes to everything else. I can live with what's in this bill. I just think this bill should have the balance of the alignment in it as part of it.
Representative Wheeler.
Thank you, Mr. Chairman. I simply can't live with this bill. I look at page 2, section 8, at line 8, read that multiple times over, and still don't know what it says. It makes no sense. And to put yourself in the position of a prosecutor standing at a preliminary hearing or before any judge at any level and trying to prove that garbage is virtually impossible. So I just, you can argue all you want to, but my vote's no on this because you don't know how high you need to let the weather balloon go before you hit the fog. Thank you, Mr. Chairman.
Representative Humphreys, I skipped you. Okay. Representative Jennings.
Thanks, Mr. Chairman. I just wondered how Representative Wheeler really feels about this.
Further discussion on the amendment. Representative Samsel.
Thank you, Mr. Chairman. This committee does a lot of really good work. So anytime we've got disagreement on it, I like to have those fleshed out and, of course, the conversations where necessary. I think I will be joining the good representative given his concerns. I perhaps learned my lesson on a recent bill involving different issues where there were no opponents, that I don't know that was, in my opinion, the particular best work that we've done. So I will likely be joining the good representative and voting no. Thank you.
Still on the amendment. Any discussion? Seeing none, Representative Jennings, you can close on your amendment.
I close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. The amendment carries. We're back on the bill. Any further amendments? Do not, Representative Carmichael.
Actually, it's not amendments, but I do want an opportunity to discuss the bill, the principal bill at the appropriate time.
Very good. Any motion on the bill? Representative Hoheisel.
Thank you, Mr. Chair. I move that we pass out HB 2229 favorably,
Is there a second?
as amended.
Thank you. Is there a second? Representative Neely, discussion. Representative Carmichael.
Thank you, Mr. Chairman. First, I think we ought to perhaps inform the committee there was a discussion between Representative Wheeler and myself regarding the circumstances under which theft of United States mail, not necessarily what's defined here, because the definition here is broader, but what constitutes a violation of federal law. And we received an extensive memorandum with supporting information from Robert Gallimore of Legislative Research. I think I would paraphrase that to say that if a mail package is left on the porch, it may be considered delivered. And at that point, perhaps it's not a violation of federal law to steal it. If, on the other hand, it is placed in the postal box, and I remember when I was a kid, it used to say on our box, theft of United States mail out of this box is a federal offense, investigated and all that, then it arguably may be a violation of federal law. And that may be somewhat of an oversimplification, but I wanted the committee to understand that Mr. Gallimore did good research for us. And at least that's what I gleaned from that research. Now, with respect to the merits of this bill, it is the crime du jour. 3 years ago, 4 years ago, 5 years ago on this committee, the crime du jour was scrap metal theft. And boy, we sure managed to screw that up, because I think the last time I talked to the people at my police department, they're a lot more concerned right now about scrap metal theft, that they can't prosecute people from stealing the converters off of cars. And, you know, we really messed it up. And I think we're in the process of doing that again. I mean, let's be reasonable here. None of us want something stolen from our front porch. But the way this works is that somebody going down the street steals 3 packages of bubble gum that were delivered by Amazon, they've committed a felony. Somebody who goes down the street and steals 3 kids' bicycles that are worth $150, they've committed a misdemeanor, maybe 3 counts of a misdemeanor. This is not proportional. This is not what we should be doing. We already have statutes that cover stealing things from the porches of citizens. And the fact that it was dropped there by Amazon instead of left there by a child who was going inside to eat their supper shouldn't matter about the penalty to be imposed. Or to steal an example from one of my colleagues on this committee, you know, wedding rings, they're important to people too. If somebody steals my wedding ring, it's not worth $1,500, but I wouldn't take all the money in the world for my wedding ring. And, you know, you just got to make hard decisions. And no matter how difficult it would be to have my ring stolen, it needs to be measured by the same standard as any other theft. And so I am not going to support this legislation. I appreciate you all hearing me out. Thank you.
Representative Jennings.
Thank you, Mr. Chairman. I would just say if you look under paragraph B, small b, and look at paragraph 5, subparagraph 5, this section, this new section was patterned after a law that was already on the books about serial thefts. And in that case, it was serial thefts from mercantile establishments occurring within 72 hours. That's kind of the habitual chronic shoplifter that's going from business to business to business, stealing property that has a value of less than $1,500 and doing it on a repetitive base, and receiving an enhanced sentence for having done so. And this porch piracy looks almost exactly as that does. It acknowledges that there are circumstances where, because of the character of the offense and the repetitive nature, notwithstanding the value is below $1,500, it becomes a bit of a more serious kind of chronic ongoing thing. And I would have thought maybe my friend from Wichita would have noticed in that paragraph the same pattern of construct. And if he was so offended by the notion that stealing bubble gum from 3 stores would constitute a felony, that he might have brought an amendment to strike it, but he didn't. And I know he reads all of these bills very carefully, so it seems as if he's okay with stealing gum from 3 different stores in 72 hours being a felony, but not taking property delivered on one's home porch on 3 occasions in a short period of time, having a value less than that as being a felony. I'm not quite sure I understand the logic there, but it seems that's the case.
Representative Samsel.
Thank you, Mr. Chair. I'm not going to offer a motion or substitute motion to table this. I will say that I could be in a position to support this. I'm not comfortable doing it today, and perhaps that is shame on me. And so I respect the will of the committee. If the votes are there to pass it out, and that's what they wanted to do, but I'm not comfortable with that today. I also don't know that I've heard any particular urgency to get this one moved, but I just wanted to share those thoughts before we vote on it. Thank you.
Representative Heiberger.
Thank you, Mr. Chair. I'm sensitive to the arguments on both sides. I'm concerned about the lack of a minimum value in this section and in section 5. I think we could have somebody being convicted of a felony for a really small total value. On the other hand, I'd love to see the 2028 finally get passed too. So I'm kind of torn, but I'm probably going to vote against it.
Representative Carmichael.
Thank you, Mr. Chairman. To respond to the well thought out concerns of my colleague from Lakin, first, I did not attempt to amend the serial shoplifting theft statute because there has to be some reasonable limitation on what we attempt to accomplish in a single bill. And while I could have done that, I thought it was better to leave that law the way it is and try to prevent the enactment of another law that I feel is ill-advised. However, my friend's concern about those 3 packages of bubble gum, and so concerned that that becomes a felony, what about the 3 kids who lose their bicycles? Their $100 bicycles. Has my colleague no concern for them? Why don't we make that a felony too? In fact, why don't we really fight crime and make all forms of theft an immediate felony with a mandatory term of at least 30 days in the county jail so as to get people's attention? Thank you, Mr. Chairman.
It's like we have something to talk about in Corrections Committee next week. Any further discussion in Judiciary? Representative Hoheisel, you may close.
I close.
For the motion, all in favor say aye. Aye. All opposed say no.
No.
The ayes have it. Motion carries. Those recording their affirmative votes are Hoheisel. Those recording their negative votes, Heiberger, Wheeler, Carmichael, O'Hobison. One more committee, and I'll let you out of here. And this is one that she's there. She's just not able to. Yeah. Okay, so 2078. And while Natalie's getting this up, this is our speedy trial bill. We had a hearing a couple weeks ago. It has sat on my desk waiting for a day, and today is hopefully that day. We know this is a huge issue. We passed Senate Bill 102 last spring to give the chief some authority to delay hearings, deadlines, and speedy trial was certainly one of those. We have found ourselves, as we heard from the conferees, that we have thousands, likely 5,000 cases that are sitting ready for trial. We don't have sufficient jurors. We don't have sufficient courtrooms, prosecutors, defense attorneys. It's an issue that needs to be resolved. But we heard some, two sides of that, as we often do when we heard the testimony. And so after that, I asked the parties to get together. And a couple days ago, I heard that both the County and District Attorney Association and the Defense Bar have come together on an amendment. So I guess I should start with now having Natalie explain to us what 2078 is, and then I'll have her send out go ahead and send out the amendment, Natalie, so it's ready when you're ready.
Okay, Mr. Chairman, I will do that. And I can just do my little recap here. House Bill 2078 suspends the statutory speedy trial right until May 1st of 2024 in all criminal cases filed prior to the effective date of this act. And then it eliminates the statutory speedy trial right going forward on all criminal cases filed on or after the effective date of this act. And this email should be coming to Kathy any second.
Perfect. Okay, questions to Natalie about the underlying bill? Don't see any, so the amendment's on its way. And again, so I've actually got a signed letter showing agreement between the Kansas Association of Criminal Defense Lawyers and the Kansas County and District Attorneys Association and Mark Bennett, both Mark Bennett and Brandon Jones, I think, signed on behalf of the KCDAA. What this does is it leaves the deadline, the out deadline until this sunsets again as May 1st, 2024. But it does put in there, as you'll now see on your screen, and hopefully you have it, some factors that trial courts should consider. Again, they're listed there. There's a number of things: the trial court's calendar, the prejudice to the defendant, whether or not the defendant has asserted a right to a speedy trial, what the calendar looks for, both the counsel and the courts, availability of witnesses. Again, there's quite the list when you have a chance to look at it. That I assume, while I don't know, I suspect that's part of the compromise that the criminal defense attorneys asked that be added in there. I will make that motion, second by Representative Hoheisel, and then we'll move on to discussion on the amendment. Again, I'll give you plenty of time to read it. Any questions or discussion on the amendment? Representative Humphreys?
I just have a little bit of discussion that I'm really glad they came to a compromise. And I knew that there was some of that work going on, but I'm disappointed that it's still May of 2024. I'm glad there's a compromise. It seems like they all agreed. I think that's an awfully long time to be sitting there. So I'm not going to oppose it, but I just needed to say that for the record. I'm not happy with that date.
Additional discussion? I mean, I think we all hope, everybody involved, that this date is way more than we need. But there are a lot of cases, and we know it's going to take a long time for them to ramp back up and get everybody heard. Additional discussion? Representative Carmichael?
Thank you, Mr. Chairman. Question for the carrier of the amendment. We, of course, had one bill in front of us that would do away with statutory speedy trial going forward. as I understand it, this bill, whether it's amended or not, but certainly as amended, would not eliminate the right of statutory speedy trial going forward. Am I reading that correctly?
That is correct. I left that out when explaining the amendment. That was on line 21 on page 3, and that's stricken as part of this agreement.
And then also one of the bills we had contained a legislative declaration, which the court may or may not accept, that these are procedural in nature and shall be construed and applied retroactively. That language has been brought across into this bill as amended, I believe. Is that right?
I don't believe it's been changed. Natalie, do you
Yeah,
want
it
to
hasn't been
comment?
changed. That's a better way to
Yeah,
put it.
so, right. If it was there,
It's still there, line 23, 24 on page 3. Okay. I'll just note that I don't think our words are going to be effective, and I think we run a grave risk that statutory speedy trial may, at least for cases prior to the enactments last spring, we may already be in violation of that. Perhaps the state Supreme Court's order will save us, but I'll be happy to vote for this. I really wish that the prejudice to the defendant was the first priority of our courts in evaluating whether or not we need this extension, rather than the convenience of the court and its trial calendar. But I'll let that slide go for another day. Thank you, Mr. Chair.
further discussion on the amendment? Yes, Representative Burris.
Thank you, Mr. Chairman. I just want to confirm on page 3, lines 21 through 22, this amendment would strike that language, correct? And that language would no longer be part of the bill, correct?
That is correct.
Thank you.
Seeing no further discussion, I move my amendment. All in favor say aye.
Aye.
All opposed say no. Motion carries. We're back on the bill. Are there any further amendments? Do not see any. What's the pleasure of the committee? Representative Hoheisel.
Thank you, Mr. Chair. I move that the committee pass out HB 2078 favorably as amended.
Is there a second? Representative Humphreys, seconds. Discussion on the bill as amended, or on the motion, I guess, that we have at this point in time. Seeing none, Representative Hoheisel, you may close.
I close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Those wanting their affirmative votes recorded: Representative Owens, Hoheisel, Heiberger, Carmichael, O'Havison. Thank you, committee. Our list is continuing to grow, but we do have a couple days next week set aside just to work bills at this point in time. So everything's on the table. I'll get you a new list on Monday of what we're considering working and not. And have a good weekend. No meeting tomorrow. It was called the chair, but we'll get caught up.
Mr. Chairman.
Thank you. Oh, Natalie.
I just was going to point out, I've noticed a couple technical like commas and things missing in these balloons as I stare at them while they're open here. And so I would just ask for your permission to make any technical changes as needed in the reports.
You've got that. Thank you.
Thanks.